And that's where we cross-reference the other rules that talk about false statements, including the 8.2. So that, I mean, the challenge here is to come up with a bunch of different comments that basically say the same thing. And the other part of it is that we want to, so what's not free speech is false statements. And it like the Pavone case says, false statements are not free, that are not protected. So even I thought that wasn't, I mean, if you're a private citizen and yells something false, that should be protected by free speech. But Pavone, like under Brandenburg, and that's what it cites. So you can't just go out. I know. I know.
Well, but it can't be defamatory.
Right, but that's so. But that's an.
But Pavone was calling a judge, you know, a succubus. I mean,
was that? Yeah, that was Pavone. Yeah, no.
So,
but so in the connection with the representation under 8.4, you cannot. I mean, you can't make false statements. You know, and recklessly statements that are reckless disregard for the truth. So
Cassidy, Topeka has her hand up.
oh yeah, sorry, Topeka, go ahead.
So just to weigh in on the point you raised, Cassidy, in the comments, that's also how I read the Marla Brown opinion. I would think that also that this comment would apply regardless of whether the statement was made in a personal or professional capacity. But I think the Marla Brown opinion was a little bit of both. If I understood it correctly, it's the account identified her as an attorney, but then it was a private account. And I think the court referenced that she was making the statements as a private citizen. So there was a little bit of both elements there, but I would think that this comment would apply whether it was made in a personal or private capacity.
So so Emil's right that it was a private account, so that it wasn't public, right? Okay. So
well, I don't think that's what she said. I thought
that's what she. No, that is what she said.
A private account, insofar as someone made it in their private capacity, like not an official law firm account or something like that.
Like it's
not
not
private, like others couldn't see the posts. That I'm not certain of. I thought that the posts were visible to the public.
Okay.
If it's Twitter, I think that's how Twitter.
Right. Emil, is that the distinction you were making, Emil?
Yeah.
Well, I was just, I had originally said something that was not accurate, and so I was just, but I think you had captured what is actually accurate, which I think the issue is that private citizen versus private account.
So you're saying, Deepika, if she is if a lawyer is a private citizen going on Twitter and making a public statement that falls under this, how could it fall under this rule if they're making it as a private citizen? Is my question. Okay.
Well, I think that was what Cassidy has flagged in the comment, if I'm understanding it correctly, that in the Marla Brown case, that was one of the mitigating factors. I don't know if it was necessarily the dispositive factor, but it was something that was important to the court. And I believe the intention of the comment would be for the restriction to apply whether someone was making the commentary in their personal or private capacity. Is that right?
Yeah, but can we say that is my question?
Can we square those two? Yeah.
Yeah, because if it's in a private capacity, does it fall under the rule because let me pull up the rule again, or hold on. Because it has to be in connection with a proceeding. So you would be a lawyer in the proceeding making the comment.
Right, the distinction.
Yeah. So
what the decision says is it was found to be protected because her responding speech was communicated in her capacity as a private citizen, expressed her personal thoughts, emotions, or ideas, and was completely unrelated to the practice of law. Those are the three things that they looked at for First Amendment protections for Marla Brown.
So completely unrelated to the practice of law in her private capacity, and what's the third thing?
And it expressed her personal thoughts.
No,
But she did identify herself as a lawyer.
She did
in those posts, and so I think that is relevant in the sense that this is the point being that we're getting very close to First Amendment protected speech issues here. Novella, it looks like you have your hand up.
Yeah, I was wondering if we're trying to elaborate on what is covered in the rule based on its language, or are we trying to add to that, but given the First Amendment constraints, because it's not clear to me that the rule language itself would preclude the like free speech issues just identified. So I'm wondering like what the project is. Are we trying to match the rule language or match the rule language and match the free speech concerns, even if we think the rule language could be construed broadly to, in some instances, have free speech problems?
I think,
It's a really good question.
yeah, wait, but so I lost the last part of your question because I was thinking about what I wanted to say. So ask your question again.
Yeah, like I think the rule, one project would be, we have the rule language and what can we add to the comment so it covers these scenarios. But then I think another project is the free speech issues aren't necessarily encaptured by the language in the rule. Like there could be circumstances where it would be a violation under the rules, but then once you put the free speech overlay on it, it doesn't work in that application. So I'm wondering what the goal is with how we frame the comment.
Well, okay, so what I think this particular rule is narrowly drafted so that it avoids free speech implications. The rule 3.6, like I think that you can, that's why I'm saying like you can say something that's true or an opinion, but if it materially prejudices the proceeding, you can violate 3.6. So I don't think with respect to 3.6,
Yeah.
I don't think we have big free speech implications as long as you fit within materially prejudicing the proceedings.
So-
and public dissemination.
Correct. So 3.6 is narrow. It applies to a lawyer who is participating in the case.
Right. So there's a temporal limitation. So if there's, if it's after the case is over,
I thought
There's-
it said participating or has
Has
participated.
Correct.
So it could still
But it's-
apply if it's,
go ahead.
if you're like, if it's over.
Right.
Okay.
So
Well,
like,
I don't know, but then how does it materially prejudice the proceeding?
Because you can't say, like, for example, after a criminal trial, prosecutors can't say
Yeah.
things after, like, about the jury's decision
Right.
or evidence that wasn't presented, like,
But that's in a different rule.
It is, but I'm just talking about like how
How
the
we
rule has
could,
already contemplated that you can affect a proceeding after it's concluded.
you might have 1.6 information, you might have protective order covered information.
All right.
But like the idea would be a random lawyer could comment on TV.
Right.
But we could comment on TV, but like the lawyer that's involved in the case or was
Is
involved.
not
should-
supposed to.
yeah.
Okay, so there's not really much of a temporal.
As
But
you were
it's
saying.
but the speaker is narrowly tailored to the actual participant.
Okay.
So when I read Judge Wendy's, she was thinking that it doesn't apply. Rule 3.6 does not apply after the proceeding's over, and it actually, but only as long as there's a substantial likelihood of materially prejudicing.
Yeah. So I think context to some extent.
Yeah.
So where we started with this in March, I think, when this was first discussed, is that the judges want to make it very clear that this type of speech is disciplinable under the state bar rules. This committee was very concerned about the free speech implications of that, and especially like prior restraint issues. A lot of the rules of professional conduct do have this like comment that says, so long as this rule doesn't impede your First Amendment obligations, and whether or not that addresses the prior restraint stuff is unclear.
Right.
And so George, the chief prosecutor, met with us and talked about how these things could already be violated. And there was a conversation about how it's not really clear in the rules that this conduct would already violate some of these rules. And so I think the trial publicity rule is actually less of a problem because it's tied, you have limited free speech rights because you're part of that case.
Exactly.
It's these other rules, so 8.4, 8.2, and I think there was talk of putting this in 4.1 at one point,
Yeah, but I think we
and I think we
Drop that.
moved past that. But so, as it relates to 8.2, 8.4, and then possibly 8.4.2, which is the
Which-
proposed civility rule if
We'll
adopted.
get to that, I know, because
Um,
that is another, go ahead. sorry.
Yeah, the issue is, essentially the Marla Brown case and all of these, free speech rights of people that are not within the proceeding. And so that's the issue here, is figuring out where the line is.
I think, right, and I think the line, I mean, I think when we get, so this free speech line, when you get out of 3.6 is if it's false or an opinion that can be proven true or false, the reckless disregard for the truth, right? I mean, so basically false statements. Or it's incitement. I mean, if it's unlawful incitement, which is just your basic free speech, First Amendment type analysis. And so I think that's where, that's our safe space. Like we can't, if we go beyond that, then we're going to run into like the Michigan case, so that's what I was thinking about when I was drafting these comments. Although I don't think I talked about the incitement issue in any of the comments, but I think it should be in there somewhere. But the thing is, and that leads me to this question of the comments that do say, but, this doesn't, if free speech basically trumps the rule in like 8.4 and like, where do we have that? It's 8.4 and is it just 8.4 that has the
Of these rules, yes, and it's in 8.4.2 if that is approved. 8.4.2,
Oh, right,
for
right.
those who forget or have not been here, is the proposed civility rule that's been pending before the California Supreme Court.
So and so the comments that say, what does it actually say? This rule should not interfere with the free speech rights, right?
Yeah, these rules prohibit those activities of particular lawyer that are protected by the First Amendment of the U.S. Constitution and then the equivalent in California.
So I think the reason why there's nothing more than that is that, it's opening a can of worms as to what that means. And now we're kind of going into that territory, which is we're further defining the limits of free speech in the context of, threats against judicial officers. And that's sort of difficult, I think, and that was the reason why that's not, elaborated on in the other comments that talk about the free speech. And that's what I'm kind of trying to get to here and the comments that I added to other rules, which is saying these things are not protected by free speech. And what I think needs to be added here is the incitement, unlawful incitement.
But what we're looking at right now is the 3.6 language. I think you want to do that for
Well,
the other.
Yeah, but I guess what I'm trying to say here is that if you are a participant in a trial, a participant in a trial proceeding, or were a participant in a trial proceeding, and you say something, but that's not that does not substantially materially prejudice the proceeding, you can still. But you can what did I say? You can still be the basis of discipline. You can violate other rules if your statements are false or cause incitement. But I don't know. Maybe that doesn't make so. Maybe though, it doesn't make sense to put that there.
Yeah, I think comment 3 is very helpful. I'm not as sure about comment 4.
Okay, so take out comment 4. But because what I was saying, I don't know. I think I was trying to like put things together that probably I overcomplicated it.
I couldn't tell that the judicial officer safety issue was a concern until you provided more context. So I'm not sure that someone reading the rule language or even these comments would think to connect the prejudice to the proceeding to the safety of the officer.
So you
That's a really great point.
Yeah. So we should elaborate in comment 3 what we're talking about, which is, we want, I mean, I get, so maybe we should come up with some language that basically says,
So you have what extrajudicial statements are. Maybe it's just another comment that talks about, for purposes of this rule, prejudicing the proceeding, so let me get the exact beginning of the rule. Materially prejudicing an adjudicative proceeding means or includes statements that because what we're getting at here, there's a leap here. So once judicial safety is at issue,
Right.
the proceeding has to either be postponed or the judge may have to recuse because they are embroiled at that point because of their safety issue. And so that's what
So it's not the safety itself, it's the implication.
it's what happens because of
the improper.
correct.
Okay,
It's how that threat impacts.
Okay,
the.
right. So we've got,
Proceeding or whatever, yeah, which that is not as clear.
so we have extrajudicial
Causation.
statements may include statements concerning judicial officers and staff who preside over the matter. Which is fine, I guess, but what we really want to do is define materially prejudice to include threats.
So
Right.
you've defined, so if you're looking at 3.6A, do you want to scroll up just
Yeah, I
so
wanna-
everyone can see A?
A,
So what you've done here already, so you have extrajudicial statement in A, which is now defined or clarified by the comment. You have what means of public communication is clarified in the comment. What I think is just missing is the substantial likelihood of materially prejudicing, like what that can include.
So we have to just add another sentence for purposes of this rule.
Correct.
Substantial, okay. So go and then delete the highlighted part and just add there for purposes of this rule, although we can, there's too many for purposes of this rule, but whatever. And then what's the,
It's substantial likelihood of materially prejudicing, which we need to change the tense here, but
and adjudicative proceeding. Take out the and.
when you're done.
If you wanted to keep the First Amendment restriction on it, you could say an extrajudicial statement intended to incite violence against a judicial officer staff is an example of one that is substantially likely to materially prejudice the adjudicated proceeding.
Well, I think that creates too high of a standard, because it doesn't have to necessarily, that's the point here with 3.6, is that it's so narrowly tailored that you don't need to meet that high threshold of incitement for it to materially prejudice the proceeding.
Well, proving intent.
Okay.
So I think you could say for purposes of this rule, extrajudicial statements that require, that necessitate, and necessitate could be a trap, but postponement or judicial recusal.
Or extra
Result in?
security. I mean, aren't the judges just worried about
there's
anything that threatens them?
Right.
Well, I think we need to actually say that.
I mean, that's why I'm so concerned about this.
I know,
that-
yeah.
What's your concern, Brandon?
That we can't fix this here.
It's
That, so my mom was a judge and we got plenty of threats. But I don't see this as the fix. And I know that judges seem to think this will help. And so I am sympathetic to that.
Well, yeah, I mean, that's why we're putting it in a comment. I mean, because the overarching goal here, and we'll get back to the language, so keep your spot, is we're putting them in comments and we're going to also publicize it so that it's through the ethics quarterly or an ethics opinion. But I think when we get to the quarterlies, I would propose this to be our first quarterly, so that it's out there. So lawyers, there's nothing specific in the rules that talk about, what you can and can't say when you're criticizing a judge in a case that you're on, and I don't want to say it should have a chilling effect on that, but there should be something that gives them pause before they go out and start, threatening. And I think it makes sense to have some guidance about, yeah, you can go out and criticize a judge, but there is a line that you can cross when it turns into, something that's threatening. And that's what we're struggling with, is that line, but
I don't know, have you already in this context talked about like the other, like older rules that have been declared unconstitutional because like offensive personality.
yeah,
666A,
that's the
that kind of
words
stuff?
case or something.
Wench, yeah, we've talked about wench.
Well,
Because we might go through this whole exercise. and then
Exactly.
it's like, cause
we don't want to have to go through what happened
but
there,
like
yeah.
what we're abutting right now is it's not like we're not disciplining lawyers because there isn't a rule and they're not on notice. We are abutting like the First Amendment.
Yeah.
So it's, and then like, we know that this rule is already sufficient to prosecute in certain circumstances because there was, Pavone was disciplined, and then there was also that other attorney who was, Chris something, the Culver City guy who was saying really offensive things.
To the
the
woman
counsel.
about the CUNT?
No.
Sorry.
He, I
that
don't,
the
I
guy?
don't know.
That was San Diego.
A participant has enabled it.
I think his name is Chris Hall, maybe, but he was the one that was telling opposing counsel to like eat a bag of.
Oh, yeah,
things.
yeah.
That was the see you next
Doritos,
Tuesday
yeah.
guy,
Oh,
right?
I don't know. He said that.
Okay, so then there was another big, I feel like that was in San
He didn't spell that word. In open
That's right, he
court.
told-
She said
He
that.
told
Even
the
if
person,
all he did.
I will.
Yeah, and he was like, he literally,
Yes.
yeah,
Yeah.
yes, and then the staff had to go tell the judge is
judge-
like, that's so nice of you to say
The
right,
thank you.
right.
bailiff
exactly.
explained to the
Exactly.
judge what he was doing.
Oh, Lord.
We discussed all that during, so that's part of the civility rules
Yes,
analysis,
yes,
yeah. But,
But like Donald
Trump?
got in trouble for saying things about the staff during his trial, and so.
Well, that's all part of it, but but like,
He didn't get
I
in
know,
enough
I mean,
trouble.
I don't think anybody disputes that, that all of that conduct is action, disciplinable, because it has been, and
Yeah.
these, and that's what we're saying, is that these rules apply to that. We just want it to, the judges, CJA, and I think we want to make it
More
clear.
People that have not read these 3 opinions that
Yeah,
this.
And so
That's
the
rad.
judges hope with us changing the rules is it will do what on their behalf?
it will create awareness in the legal community that, your speech can be regulated.
It's proactive regulation as opposed to disciplining lawyers who have already engaged in this
So
conduct.
people tone down some of the rhetoric that's.
Exactly. Yeah,
And so, but doesn't the court have its own set of
So this was. an
civility
interesting
and
point.
decorum rules in which
Courts do
they?
not, I thought courts would have ample power to enforce their own rules and protect themselves, but the judges didn't think so.
They didn't-
No, they didn't.
don't.
They
Well-
don't want to create an appearance of partiality.
in fact, their hands, they're more restricted because of that, right? Because they.
Yes,
because-
their sense is that if they take action on this type of speech, I mean, there's a particular case in San Francisco that required a judge to delay proceedings.
Okay.
Because of, because
Attorney.
a certain attorney said things that
Right.
caused problems. And so that's largely it's part of the impetus for this request. But beyond that, what the judges have explained is that they have construed their code of judicial conduct, which is the equivalent of our rules for judges, to take action on these types of things would have them be construed to be embroiled or too involved in, and that's open to
They have be
interpretation.
Impartial.
But yeah, they're no longer impartial in the proceeding because they are worried about these things. And then they also don't want like that, then that could be weaponized, right? So then you could have an attorney who says something like this,
Exactly.
and the judge is then
Required to recruit.
required to recuse themselves. So, and then they get a new judge. So because they're not, and then it starts the proceeding. Oh,
So they want to be out of it. They want
Correct.
us to deal with
regulate.
it, because then they get to, then it's out of their hands, literally, and they, but the problem is dealt with. So it's, it's,
But if we're too weak over here, it does no.
well, we're not trying, I
Not
mean,
weak,
there's only
I
so
don't
much.
mean weak, but if it doesn't have teeth, enough teeth.
Well, and if
then
It will
means
never
you
have
got-
enough.
And if it can't have enough teeth because of the First Amendment
Yeah.
restraint. So it's a very fine, it's a tiptoe here in calling this out, having a comment that actually can pass constitutional muster. It's tricky.
So that's why I'm trying to say, like, reasonably well below the line, crossing lines. So we're talking, and the judges agree with they're like, we're only talking about false statements, I don't know if that necessarily gets at, what they want, because you can still be threatening.
Without-
Right, without false
So
statements.
it's either
Right.
false statements or, unlawful incitement, which it has to be imminent, it has to, all of the constitutional, it's a very high threshold. Or, but they know that, they know that that they understand the free speech implications that, because. So, okay, so let's get back to this, and then I want to talk about the civility. Because I think anyway, let's get back to this.
I was thinking that, won't that take care of this?
I think the second sentence might be too broad, like you could say, I don't know if it's supposed to be construed within the false part already applied, but it's
Are you talking about comment 4, or are you talking?
the extrajudicial statements that necessitate postponement.
Comment 60, line 60.
No, she's talking about the.
Line 56.
Line
That was just,
55.
yeah.
55.
Yeah,
okay.
55 through 57, like if I say, I'm in a proceeding, I'm participating in the proceeding, and then after court, I learned that my judge got paid money under the table. If I say that outside of court, that could necessitate the judge's
Right.
refusal, but it's not because I shouldn't have said it. I mean, I should also say it in the proper format so that it can be
So I
dealt
think
with
you need a
appropriately.
for safety type of qualifying language. So actually, the necessity of postponement or judicial recusal.
So I don't know if it's like,
That's a
we want
good
to add
question,
in
though.
the
Wait, so-
safety thing, or we want to add in the falseness, or both, but it seems like it needs a qualifier.
So you don't. So if you think, well, I'm sorry, I'm kind of not addressing your exact question, because you think that if you found after the proceeding or during the proceeding, if you found out that the judge is taking bribes, if it, and I think if you went out and said it publicly, does have a substantial likelihood of materially prejudicing the adjudicated proceeding. That would violate this rule, but that doesn't seem right.
So, yeah, I guess if you scroll up to the rule
Do you know what I'm
language,
saying?
That's what I think you guys are saying the exact same thing in a different way.
yeah,
Wait, so it has to be threat.
does it have to be false, or is it just?
No, that's what I'm saying. It doesn't
Yeah,
say that it has to be
okay.
false. But so, is that true? Okay, the rule is a lawyer who is participating in a proceeding, let's just say that, shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication, and 2, have a substantial likelihood of materially prejudicing an adjudicated proceeding in the matter. So you, lawyer, in the adjudicated proceeding, learn that your judge is taking bribes, and you go on TV and say, the judge in my case is taking bribes, and it's true. It still violates.
It's not prejudicing the matter. No.
It's not? It's not?
doing the opposite of that.
It's like, okay, okay, I just want to get, like, am I wrong?
California's 8.3 does not require reporting judges.
Right.
But it's the opposite of that. It's maintaining the integrity of
By
the.
saying- by-
okay.
By disclosing.
Okay, I just wanted to throw out that hypothetical and make sure that, because it doesn't seem right that that lawyer would be disciplined for
And
calling
we
it.
have to define prejudicing proceedings.
Right, I mean, so, but okay, let's get back to your, because that's what we're
Yeah, I mean, I think it would help to define,
prejudicing.
yeah, so, because I didn't realize that the public safety thing was an issue just from reading that language, so.
Okay, so for purposes of the extrajudicial statements that necessitate postponement or judicial recusal, so you have a problem with that language?
Could you add to protect judicial officer and court staff safety? after judicial recusal? Create a substantial likelihood?
Extrajudicial statements that necessitate, I mean, how do we just say threats, like, or like threatening comments or comments that give rise to threats?
Let's see what 420.
You could say extrajudicial threats, but I don't think that.
But it's not, you could say something that that's reasonably foreseeable to create threats by third party, other people.
Right, so that's what happened. That's the
Yeah.
case.
Yeah.
That this is trying to solve. So, I mean, I think if you're saying extrajudicial statements, because it could not just be threats that necessitate postponement or judicial recusal for judicial officer, court staff, safety.
As a result of jeopardizing the safety of judges or judicial officers or staff. So something like help. For purposes of the extrajudicial statement, then say postponement or judicial recusal because of threats against their safety. Something like that.
Could we put it on the front end? Extrajudicial statements that threaten judicial officer safety and thereby necessitate postponement?
So there's a penal code section that covers this conduct, penal code section 69, and that one says threats or violence to prevent an executive from performing their duties. So maybe we could try and mirror like the PC 69 language.
Good idea.
And judges are covered under
Yeah.
PC 69. So are meter maids.
Okay, so criminal offense that prohibits the use of threats or violence to resist an executive officer while they are performing their duties.
So yeah, it says by means of threat or violence to deter or prevent an executive officer of any duty imposed upon the officer by law or who knowingly resists in the performance of their duty. But so maybe we could take something from.
So extrajudicial statements that.
Are you guys able to see our chat?
No one in the room can see it,
Yeah.
Vikita, but us, because we're the only ones on the computer. So do you want to just say it?
Yeah, any attempt to intimidate or coerce judicial officers, court personnel, or interfere with the impartiality of the judicial proceedings constitutes a direct threat to the integrity of the legal system. Such behavior is not only unlawful, but undermines the independence of the judiciary, potentially leading to severe legal consequences.
Or did you come up with that, or is it from something?
I just wrote that.
You did, okay. No, I didn't know if you were taking it from like another statute or something. So you came up with that.
Yeah.
Okay. Can you read it slower, or can we cut?
Yeah,
Do you want,
I-
can you add it in?
Yeah, I'll
Thanks.
just.
I'm gonna run. Can I run to
And
the
then-
restroom? Am I allowed to run to the restroom?
There's no potty breaks, Cassidy.
What are the
You
rules?
You put it, Akita, you put it in the chat?
I did.
Okay, so Angie has it.
Angela's bringing
Okay.
it up.
And then can we also put what Topeka said?
Topeka may have to repeat it for us, but then yes.
So
And just a sec, Topeka, 1 sec for Ange to get the other language.
The other language is right here, what Vikita just said. And then Topeka, did you have an addition or do you want me to add it into the beginning here?
So I really like this new language that Vikita added, but maybe we could write down what I suggested and wordsmith. So for purposes of this rule, extrajudicial statements that threaten judicial officer safety and thereby necessitate postponement or judicial recusal create a substantial likelihood of materially prejudicing.
Create extra substance.
Create a substantial likelihood of material
You're not-
prejudicing.
Yeah.
So just the rest of the sentence, yeah.
Oh, oops. Okay. And Vaquitas is after.
Is
the
right after the
highlighted part?
highlighted, after the highlighted.
And that covers that penal code section too, right? So. I think both sentences look good together.
Do we need to be more closely aligned to that penal code language in the any attempt?
Pull up the cal term for that too, to see what.
I think we should include a reference to, if it changes at some point, we might flag it. Maybe.
Copy and, give me 1 second, I'll copy and paste the penal code.
We can simplify the structure of the comment.
Oh, also if,
We voted with that.
It's done, meeting's over. Can you just put this on its own on the screen, just so people can see what the penal code section is?
do we need to put any scope around, so under the, any attempt to intimidate a judicial officer, what if the attempt to intimidate them is not in connection with a judicial proceeding?
We're still on 3.6, so
It's assumed.
It's assumed. Like, what if a lawyer and a judge like run into each other in the parking lot and they're like yelling at each other?
I mean, I don't think that's a 3.6 issue.
Wouldn't think so.
Because the rule is trial publicity. So if it's in a parking lot, it's the two of them, it's not.
Right.
So it's an 8.4 issue.
The camera crew is there.
Yeah, but then the camera crew is there and there's jurors in the parking lot.
Well, okay, interfere with the impartiality of. What about we say interferes with, like, combine the penal code interferes with the duties of a judicial officer and its staff? Or something like that. Constitutes.
Well, with that, I mean, if your clerk is threatened, that would interfere with the impartiality of the judicial proceeding.
But what does interfere with the impartiality of a judicial proceeding mean? I don't know what that means.
Very good question. I think it
just interferes with the duties. That's why I'm thinking like interferes with their ability to do their job.
So could it just say any attempt to intimidate or coerce a judicial officer, court person, or court personnel
Still does,
that deters or prevents? That's the.
or threatens the safety. I mean, I think we need to put safety in there somewhere. Any attempt to intimidate or coerce judicial officers.
So going back to above, for purpose of this rule, extrajudicial statements
Oh.
threaten judicial officer safety in a manner that deters or prevents. I mean, if you're trying to get all of these things, it's a lot.
In a manner that deters or prevents in a manner that deters or
Prevents a judicial officer.
from doing their job, from performing their duties.
Are we trying to say in a matter or in a manner?
That deters or prevents a judicial officer from performing their duties.
What about attempts? Because what if it's not successful, but they're still trying to do it?
Well, but that's,
Extrajudicial statements that attempt to.
oh, I see what you're saying. I thought you said I thought you were talking about performing their duties. I'm like, no.
No, I just don't think that they should get like a caveat just because the judge is not actually,
Feeling threatened, yeah.
is not deterred or prevented from performing their duty.
That threaten or attempt to threaten.
So you're gonna need to probably also define judicial officer.
Because earlier we say judicial officers and staff at the beginning of this.
Right, and to do that, you're gonna need to move, I don't think we define terms used in a comment in another comment. I think the word judicial officer would go into the rule. And then I think you're looking at probably like some sort of 3.5 language about what a judicial officer is and includes, which includes court staff and all that. But that's not that's a defined term only within 3.5, so.
Wait,
Because otherwise it has to be in rule 1.0 and have an asterisk and all that.
well, can't we just reference 3.5 and say that's what we mean?
That's fine.
Yeah.
Yeah, because if you look at 3.5C, as used, it says, as used in this rule, judge and judicial officer shall also include. So I guess if you reference rule 3.5C as in Charlie.
It just seems a little clunky in a comment.
Well, where are we? Can we put that off for a second and then draft the rule?
Yeah, definitely, yeah.
Okay, so for purposes of this rule, extrajudicial statements that attempt to threaten, that I would say that threaten or attempt to threaten. So good of that.
Did we want the attempt to go with the threat or with the deterring or preventing?
Okay, hold on. Threaten, attempt to threaten. Judicial officer statement. That deters or prevents or attempts to deter or prevent.
Oh, boy.
Yeah, I guess I thought,
Or
I thought
both.
when you were saying it, you were saying that if someone tries, but it doesn't actually have that effect. So that's why I wasn't sure where the attempt went with.
I think it's the attempt to deter or prevent is what we're trying to
Oh,
regulate.
okay. Not the threat attempt
Okay, so-
itself, but the
Not attempting,
Implication.
not attempting to threat, but attempting
Right.
to deter.
But then you have to prove intent.
No, I think it needs to deter for it to fit into the rule. I think,
But then the lawyer gets to benefit by the judge just being so like,
Super tough job.
so professional and chill that the lawyer gets to
well,
Well, would the penal code cover the attempt and the actual act for criminal prosecution and then the?
yeah, it does based on, I looked at the CalCrim, which is like the elements that the jury would have to find true, and it has attempt language in it too.
but attempt isn't part of 3.6A. It still has to have a substantial likelihood of materially prejudicing the proceeding. So I don't think you get there with just attempt.
Then what if we change in a manner likely to deter or prevent
Yeah.
a judicial officer from performing their duties instead of that?
Oh, wait, we're defining, okay, hold on.
So in a manner likely to deter.
But if the judge doesn't postpone it.
No, but it's likely to deter or prevent a judicial officer from performing their duties. Oh, but then,
It doesn't substantially prejudice the proceeding because the judge said, I'm go for it. And just moved on with their calendar.
But then they can't report it or be.
Well, yeah, I mean, so
So under 3.6.
Right.
I think we're spending,
Got it.
so 3.6 is like, it has to do something.
yes.
Doesn't have to do
It's,
everything.
right,
Yeah, I think what we're trying to solve is in 8.2 and 8.4.
Got it. Okay.
but we're just just.
We're just looking at 3.6. It's fine. No, you're
We
good.
kind of lost
It's
the
all
plot
good.
here, but.
This is just things that actually get delayed.
Yeah, so this is where, I mean, this is actually where probably you're gonna have more teeth, you know, because it's where there's, you know,
The lawyers associate, you have, the lawyer has more limited First Amendment rights.
Yeah.
Because they are acting as the lawyer in the
Mhm.
case.
right.
So this is like the Bates, Arizona stuff, like all of the justifications for reduced rights fit here. In 8.4 and 8.2.
And you know-
it's harder. That's
And
the
you know
Marla-
why, and you know why this is important here, I think, is that those lawyers, you know, who go out and like criticize and blah, 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 you know, during a proceeding, they're probably thinking, well, I have free speech rights and I know that, you know, I just don't have to say anything false. I just don't have to, you know, incite, but I can go out and criticize the judge however I want, as much as I want, you know.
And the political pundit on whatever, you know, the expert lawyer commentator on a news whatever is not the lawyer in the case, and that's
Right.
very obvious.
Right.
In this situation, it may be taken more seriously, as it was in this instance that we're dealing with, because they are either the lawyer in the courtroom or they are the lead lawyer of the office of the lawyer in that courtroom.
Right.
Making these statements.
What about you using the pundit as your mouthpiece? Like like as your agent, like you're the lawyer in the courtroom and you say, hey, you know, Giuliani, go on TV and talk about this. So I'm not in trouble.
I think that then you're looking at 8.4 and 8.2.
Well,
I mean, in theory, the
I think it falls under 3.6 because your extrajudicial statement to Giuliani, when you reasonably know it should be, you
But
know,
was that public?
it's not a public, yeah.
no, but it's an extrajudicial statement that you tell Giuliani to go make the public statement. So you reasonably know that it's going to be disseminated by means of public communication and then have a substantial likelihood.
I mean, I would say it's a bit
I don't know.
paternalistic that lawyer who then goes and does that doesn't have the agency to say, I can't do this because it's going to violate my professional responsibilities
That's true.
obligations.
And then you have like a
The same
conspiracy.
concept with like contacting an unrepresented party.
Right,
You can't do it
exactly.
indirectly either.
Exactly. That's what I was thinking. Yeah. But okay, whatever. Maybe I'm just like,
I think 8.2 and 3 and 4 are keys.
8.3, are we
Oh,
talking about?
sorry.
No. I think,
Yeah,
I think if we can
8.2.
figure out 8.4, I think we can come back to this and figure it out.
All right, so do we want to just like,
We can leave
Put
it
a pin in
class
this?
and yeah.
Oh.
Great.
all right, let's go to 8.4.
With the penal code.
I don't even remember okay, 8.2. Oh, you can go to 8.2, actually. Okay. So let's read the rule. Yeah, a lawyer shall not make a statement of fact that the lawyer knows to be false with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge. I mean, or a judicial officer. So that's the kind of the key phrase, qualifications or integrity. And integrity is broad. I mean, like that can include everything that we're talking about here, I think. Okay, so let's go down to the comment.
And so this is the Pavone issue,
Yeah.
but it wasn't false.
This one, I think we just need to change the word trust to
was
truth. Line, or for me, it's line 90, I think.
Well, I mean-
Line 103.
103
Yeah,
Proof of
essentially
it.
false statements and false statements made with breast.
for the truth.
Also wasn't charged under 8.2.
I know that, when I just saw that, I was like, wait, that was from, they could have charged, that seems
Because
better.
no one thinks 8.2 applies. Outside of judicial functions.
So this is where I am saying that there's no First Amendment for, that you don't have First Amendment protection. Right? What am I saying here? Because we're still not talking about threats directly in the comment.
I feel like that first sentence though, I mean, do we even need it in the
No.
comment? It's restating the rule and just
I know.
comparing it to the first sentence, so.
Um,
Wait, to delete it.
Can you just do strike through for now?
Yeah.
Not delete,
Not delete, I mean,
the font.
it's on,
Yeah. Yeah. Okay, right. I'm sorry, I thought it was
oh, no.
new.
Oh.
so here, like, I'm trying to think of some of the examples from the case, like, what was it, Pavone?
In Pavone, it says statements of rhetorical hyperbole or those statements incapable of being proven true or false are subject to action only if such statements can reasonably be understood as declaring or implying actual facts capable of being proven true or false. That's a mouthful, and it's citing the, yeah.
Well, it's like saying, right, and it's like saying, you know, the judge was biased because the judge, you know, there was an example of like accusing the judge of bias, and that can be proven true or false. I mean, it sounds like an opinion, but it's actually something that's just like so, you know, far-fetched, and it's implying truth based on something that the lawyer has no reason to believe is true. And so that type of opinion sounding comment is disciplinable because it's not protected by free speech if it's
So
false.
comment here is trying to say that opinions, which are usually a defense of sorts to defamation, are not necessarily a defense to discipline if it would have been kind of unreasonable to give that opinion because it's easy to prove.
Right. I mean, it's that what you just read, and I think maybe we just put that in there because what we're trying to do is saying, hey, there are free speech limitations, and you know, so we are kind of parsing out that like sort of blanket comment that says, you know, we're not trying to regulate free speech. You know, we're trying to explain that, but not all speech is free. You know, so. And the opinion part of it is what is usually the type of threatening comments that we're talking about, unless it's incitement.
So I guess my problem with the sentence over here is the declaring or implying. That just, it's a mouthful. Is that needed? Is there a shorter way to say that?
Well, I want to have a better way of saying what's in the Pavone case, and maybe can we cite, well, I'd rather cite
Well, it's
Yagman.
Oh, yeah. Pavone, it's a review department case, and then Supreme Court just,
Denied.
sorry?
They denied the petition, right?
Yeah. So.
It's a final, I think
Pavone?
it's published. It's a review department published opinion, so you can reference
Oh,
it here.
So can we, can we cut and paste what Camille just read, and then,
Yeah, one sec. What, sorry, can you just tell me the first line so I can find it in my Westlaw?
Sure. I guess statements of rhetorical hyperbole. Rhetorical
Got it.
hyperbole.
Yeah, it's in quotes.
Probably just cite to both, say.
yeah, it's
Citing.
citing, yeah, that's what I was thinking.
Because funny enough, I actually love when I see citations and comments because I know it's like looking at the annotations.
Yeah,
2023 to the site. Mine, so I can just. Problem with one screen.
You want the state bar court number?
Yeah.
SBC -20 -0.
Oh, sorry, not the case number.
Oh.
That's okay.
Looking at the state
like
bar.
a pin, you need a pin site.
I need the state bar court, the state bar court reporter site.
I can look it up.
We can all race to find it. Is it published? I don't think it is. I misspoke. I don't think it is published.
Oh, yeah, I just see Alexa's site.
Okay, so we can't quote, but is that from Yagman? Then we can just.
Yeah, I mean, they cite to, yeah,
Can we
Let's,
just read?
let me find it in Yagman real quick.
Well, they don't. Oh,
Oh,
whatever.
yeah, they've decided not to publish.
oh, yeah, it says not designated for publication.
Hmm.
Interesting.
Probably because they relied on Yagman so heavily that they.
So the Yagman language is statements impugning the integrity of a judge may not be punished unless they are capable of being proved true or false. And then what you have basically is statements of opinion are protected by the First Amendment unless they imply a false assertion of fact.
Unless they.
It's a very long quote that is
In
better
Pavone's?
synthesized in Pavone. No, the Yagman. It would be hard to put it into a comment
Well, what,
without paraphrasing it.
can we look at it?
Can we take the way that Pavone synthesized it and then put C?
See Yagman?
C, yeah.
Can we plagiarize Pavone
If I give you screen share.
without citing?
I think I have screen sharing rights currently.
You want me to stop sharing?
No, I'm just gonna take over your sharing.
Okay, go right ahead.
I'll make it bigger. Just bear with me for 1 second.
Unless they're capable of proved or false statements of opinion. Or general, unless they imply false assertion of fact. Only if it implies the allegation of undisclosed. Yeah, so this is kind of the, like what I was trying to get. Statements of opinion are actual only if it implies the allegation of undisclosed defamatory facts as the basis for the opinion. So, right, and so Pavone goes through this whole discussion about if you say the facts and you come to an opinion, that's not actionable. So if the lawyer says, X, Y, Z, but if it's undisclosed facts and you just say the judge is biased or the judge is I think a drunkard, that was one of the examples. But you don't say the facts based on that opinion and it's false. That the lawyer or the judge is a drunkard. Like the example is, I saw the judge going into a bar on Tuesday afternoon, and I know that he, drinks with his wife on occasion, and I know that he really likes wine. I think the judge is a drunkard, and so you understand that opinion is based on those facts, and you could believe that or not, But if you just say that the judge is a drunkard without saying why you say that, then I think that statement is disciplinable. That just calling the judge a drunk, and I think Pavone goes through that distinction. I think it's Pavone. Do you guys? Am I talking crazy?
No, you're not talking crazy. It's going to be very challenging to put into a.
Well, I don't think we should put that whole.
No, but the concept is very
But
challenging.
that's what that
to
concept is.
put into
about.
a comment.
The
Yeah.
undisclosed defamatory facts as the basis of opinion. That's what I'm talking about. Because that's really what we're saying here is when a lawyer goes out and says something like the judge, is biased and, it says things that are inflammatory that sound like opinions. But, that's what gives rise to these threats because people start believing all this stuff that's nonsense. And, and lawyers say lawyers say these things that have no basis in reality. And they get away with it. But that's what we're trying to say. You can't do that. And that's what this is saying. So I do think we can just say, I think we can at least say this statement, like maybe even the restatements. The statements of opinion are actual only if it implies the allegation of undisclosed defamatory facts as the basis for the opinion, like something along those lines. And then we have, we don't have to give examples, but we can cite to this, cite to the restatement or cite to, what is it, like,
This is Yagman.
this is Yagman, this case,
Yagman.
this, what? Yeah, we just cite to Yagman and they can read all about it. Right? I mean, you know, we're not gonna like do a treatise.
It's already cited in the comment, right? You already said it.
Yeah. So maybe it is Yagman that talks about the drunkard. I can't remember. Example.
Control F, drunk.
Yeah, no, well, maybe I'll look.
Brandon, I'm starting to see your position. The whole professional.
More money for bailiffs might be better.
Temper of the times.
Well, not if you're like the sheriff who shoots the judge.
Right,
Well,
that's what I'm
not all
saying.
bailiffs.
Oh, wow.
Yeah,
That's
that's crazy.
wild.
That
I
is
know,
crazy.
there's more to
And
it.
then I know, and then the word like.
There's more.
Is there a lot? Is there a lot?
Yeah.
Why it was in that, why
Yeah.
didn't it move it?
The what? Why
they
what?
didn't move it?
Yeah, some other wild stuff happened in the.
Oh, they
chambers.
kept it in. I didn't
Wow.
know.
You remember it was where- Oh, yeah.
Oh, no.
Yeah, like that was his jurisdiction. So,
Oh, and he's being charged and tried in that jurisdiction.
Yeah.
the case
get up to
issue,
date.
why they didn't move the underlying
It's not
case.
as
because-
fascinating.
What was the underlying case?
It has something to do.
I thought it had to do with his daughter.
It did, but I think it was in that, he was shooting the judge that was governing the case that he had an interest in.
Oh,
But why would you not move a case the sheriff has an interest in
right.
outside of the
That-
jurisdiction?
that
But then there was also the thing that
Some
happened in the
issues in that
chambers, like,
courthouse.
when-
Just a few.
Well, it's a small town.
Just a
I think it was like
few.
I don't
Oklahoma
think that
or
this is a first
Tennessee.
flash in the news, but I remember just thinking,
Okay.
All right.
But
We're
it's
off
hard to
topic now.
enforce this when your president does all of these things, right? So there's no rule that's gonna stop it, right?
So Cassie, going
Yeah.
back to the even statements that at first blush line that's up here on the screen.
Yeah.
I think that, sorry, because I highlight the wrong section.
Well, okay, statements impugning the integrity of a judge may not be punished unless they are capable of being proved or false. Statements of opinion are unless they imply false assertions. I mean, I think,
I think what I'm trying to say here is I think this is going to be hard to overcome.
That which you have highlighted,
Correct.
even statements.
first blush.
Wait, even statements that at first blush appear to be factual
Are protected.
are protected by the first, if they cannot reasonably be interpreted as stating actual fact. If they cannot reasonably be
Bad
interpreted as
sentence,
stating
but-
actual facts about their target.
So for like
Well, what's that mean?
I think
Yeah,
that's-
satire, but we're not talking about satire. Yeah, I mean,
But where's
That's
the
like
line?
saying-
But like, where's the line? Is
calling the judge a drunkard, calling the judge biased, saying the judge, belongs in a mental institution or, something like so outrageous. I mean, yeah, I know, like, it's hard to, but they do draw the court, that they have drawn the line. That's what I'm saying, is that there's precedence for drawing a line, and that's what, and we're not going to we're gonna say what the rule is, but we're not gonna, I mean, the rule, like, you took it down.
I'm sorry.
What happened?
Well, so I think the challenge here is that until there's so the challenge is this can already be prosecuted under the existing rules, right?
Right.
But there's no case that has frankly successfully been prosecuted under the existing rules for this instance. And so trying to create language without facts, but First Amendment issues are much clearer to deal with when there's like speech that has already occurred, as opposed to trying to draft something that predicts speech without a prior restraint concern.
But if we just say what the rule is, like the Yagman rule, which is what we're trying to get at, and I think what we're trying to do is just figure out what that rule is based on that one paragraph, and I'm losing my mind. Just like I'm like too lazy to wordsmith it or figure it out is my problem. But within that paragraph, it's there. Well, I think in the Yagman, opinions may be the basis of discipline if the opinion can be reasonably understood as declaring or implying actual facts or it's the undisclosed piece, the undisclosed facts, defamatory facts that I think there's a better way to say what I was trying to say there. And that based on that paragraph that you had from the Yagman case.
So opinions may be the basis of discipline if, and then maybe,
If, so the line from Yagman that you may want is if they include words that have specific, well-defined meanings and describe objectively verifiable matters. That's the good language from Yagman. I can
but I
put
think
it back
that's
on the
the-
screen.
opposite of what we're saying.
Yeah.
The inverse.
Because we're trying to get at opinions.
But that's all Yagman stands for.
Yeah, so Yagman is saying that that's not a protected opinion. What you're saying, sorry, that would be an example of a protected opinion. And what we're trying to say is what's not a protected opinion. Right?
Yeah, I think.
And that's why I don't like the declaring or implying. Like it's a very difficult sentence. I think the idea is an opinion is bad and can get you disciplined if it implies something that can easily be discerned as being false.
Right.
Like, for example, if I say the judge lives on the moon, that is like hyperbole.
Right.
But if I say the judge is a drunk, but like it can easily be discerned that the judge goes to AA, so if I say the judge, drinks every night, but then I can easily say by, I know it's illogical, but to prove that the judge goes to AA meetings every night, then could be proven as false. So it's like with reckless disregard for the truth of the matter, because it's like everyone knows judge is always at AA meetings. It's like, so that there would have been no basis to call that an opinion.
Right.
So why don't we just use with reckless disregard for the truth, which is already
Yeah, commonly.
and in the rule.
Yeah.
So I guess what I'm saying, like, what are we adding?
Okay, so yes, then why do we need anything?
Because lawyers think opinions are protected. The lawyers think that opinions are always protected, and that's not necessarily true.
Aren't judges public figures?
Oh my God, we're not.
I mean, don't we have to talk about all this? Like, I'm
No.
totally against threats to judges, but I don't
We'll
know.
see how to do it.
I mean, I definitely think that a citation to Yagman would be good in the comments. How do we get that?
I do too.
But I think I agree, but I think
But
we need to be very clear what Yagman
Can somebody give me this? Oh, it's right there.
stands for.
Let me look at Yagman again.
And perhaps a pin site would be helpful in this
Yeah, I think it's like
circumstance.
1439 or something is the pin site. So
Why is this so hard?
Can we just say what you said? Like, although for laypersons, the constitutional, like, free speech boundaries for opinions is this, lawyers should take caution that for them it's differently. It's
So, like,
different, and then
Site
just
Bates.
read the case and figure it out yourself.
Well, yeah, I mean,
Well, it's constrained to preserve the fairness of the
Yeah.
proceedings or something like that. I
Well,
don't,
that's-
I don't really want to comment on what it is for lay people either. But
We can just say that they're different and people,
yeah, if we're
Assume they're the
balancing their
same.
free speech against the need to protect the integrity and fairness of proceedings or something like that, so they're going to be constrained by ethics rules. And there is some constraint that's reasonable.
well, that's, I know, yeah.
I mean, if all we're doing is recognizing that fact.
Oh,
that's
Yagman
easy,
does talk
but-
about drunk. You can do a word search.
Yeah.
And Brandon, your thing about public officials is that's
Well,
part of the stuff.
I mean, these are people that run for office
Right.
and like,
Okay.
I thought the First Amendment was like almost inapplicable to public
That-
figures.
Right, that's what I
But I'm not a First Amendment person, but that's what,
What do you mean it's not applicable?
like, you can say crazy stuff about political candidates.
Okay.
Even if you're a lawyer, you can.
Listen to this paragraph about the judge being drunk. Just indulge me a little bit.
You're on this one.
Okay, finally, the district court found sanctionable Yagman's allegation that Judge Keller was drunk on the bench. Okay, so he came to work drunk.
He really did.
Yagman contends that, like many of the terms he used in his letter to Prentice Hall, this phrase should be viewed as mere rhetorical hyperbole. The statement wasn't a part of the string of invective in the Prentice Hall letter, however. It was a remark Yagman allegedly made to a newspaper reporter. Yagman identifies nothing relating to the context in which this statement was made that tends to negate the literal meaning of the words he used. We therefore conclude that Yagman's drunk on the bench statement could reasonably be interpreted as suggesting that Judge Keller had actually, on at least one occasion, taken the bench while intoxicated. Unlike Yagman's remarks in his letter to Prentice Hall, this statement implies actual facts that are capable of objective verification.
Right, but that's a false statement.
For this reason, the statement isn't protected under
It was a
Fowler
false
Bessler.
statement.
Because it's a false statement.
It was a false statement.
Yeah, for Yagman,
Because it's not that's the thing, is that's not I mean, they decided the analysis there is not that that was an opinion, it's that it was a false statement.
So if he had said, I think this guy's drunk.
It'd be fine.
That would be
but
fine.
his, I
Right,
know,
that
but
would've been
his,
fine.
right, but his defense was, it's hyperbole, it's in my opinion. So doesn't matter if it's true or false, right? I mean,
But that wasn't a valid defense, that they,
right, that's what we want to point out, is you can't just hide behind hyperbole,
Because
you
it
know?
can be proven true
Or
or
false.
false.
False, right. I mean, I know we're saying the same thing, but what I'm trying to get at is that lawyers, I mean, not lawyers, but anybody think like, I can just sit satire, hyperbole, whatever, usually, but not always. And here's this, if you read this case, there's nuance here, and you should understand that, especially as, an officer of the court. It's kind of what we're trying to convey.
so it's maybe a lawyer's defense, like that's what we're getting at, that the
Yeah.
court found that the lawyer's defense of a statement as mere opinion or rhetorical hyperbole
Right.
was found invalid.
It's found in, well, but then then it goes on. For Yagman's drunk on the bench allegation to serve as the basis for sanctions, however, the standing committee had to prove that the statement was false, and they didn't do that. So they didn't, but let's assume that they did, and they said he's never ever
That's been drunk, right, proving a negative, yeah.
which, and then the standing committee is like, how are we supposed to prove that negative?
Right.
And they're like, well, you got to do that because, but the point is, yeah, I mean, you can't just say that it's rhetorical hyperbole if you have no reason to believe that it's false, and the other side says it is false and shows that it is,
So I think my struggle here is opinions may be the basis of discipline. I think like that was the lawyer's defense, that it was opinion, but like that it wasn't an opinion. It was held to be a false statement.
I see what you're saying.
So I think if we were to say a statement that is asserted as opinion may still be the basis for discipline if the rest of your sentence that's up there.
I like that.
Yeah.
But part of it is, again, the middle of the sentence I don't like, though, still the
What is,
declaring or implying if there's a way to clean that up.
yeah.
Can you say that again?
Yeah.
Statement is asserted as opinion.
A statement that is asserted, yeah.
Under the guise of an opinion?
Sure did.
No, just say how you said it.
Yeah, I
See, we don't need
statement
to fancy it up.
No, just straight.
a statement that is asserted as opinion may be the basis, I think, for discipline, not of discipline.
Yeah.
If the statement,
If the statement,
okay, now what are we gonna say there? if the statement implies actual facts that are capable of objective verification.
Yeah.
Yeah.
Yeah, because implies, I would say implies actual undisclosed.
Well, I
facts.
even like being capable of being proved true or false, like you already have. Unless is objective verification in Yagman?
That's from Yagman.
Okay, then yeah, I do that.
Should we put it in quotes?
Is it an exact quote?
Yeah. So if the statement, you can start the quote. That statement implies actual facts that are capable of objective verification, period, end quote.
And then what page are you on, Cassidy? So we give a pin site.
It's, like
1430 something.
1441.
Do we need false or at the beginning, or is it just in the statement that it's asserted?
Just a statement.
Yeah. So that 14.
I mean, I claim that if it's objectively verified as true, then it's also not, it's also not disciplinable, basis for discipline. But I think that's what, I just leave it. This isn't going out for public comment or anything, like we can, like, we're just circulating this.
This is this is going back to CJA for discussion, or the working group that includes CJA for discussion.
Yeah, I think that's good, okay. I like this. What do you guys think? No?
Like it?
So I do too, but this doesn't address
Threats.
threats.
Explicitly.
It doesn't address judicial safety in any way, which is the point of this exercise. Yeah.
Okay, so where would we put that? A statement? What is, okay.
What's this?
I mean, again, I don't know if this is the rule for that. We're in 8.2, right?
Isn't a threat an 8.4 violation?
Correct.
All right, well, maybe we can add I mean, yeah, I mean, it would certainly, if we said something about judges' safety, blah, blah, blah. We would, I think, threats, it would be similar to 3.6. We would
Right.
say, threats to judicial safety, state extra, what is the?
Whatever you use.
Judicial, attacking the integrity of a judge can include threats to judicial safety, or includes threats to judicial safety, or something like that.
Well, I think it'd be conduct that is prejudicial to the administration of justice includes statements, because that's the violation.
Of 8.2?
No, I'm sorry. I thought we were talking about 8.4. Sorry.
Oh, no, I'm talking about 8.2. So we are, and this is the consistency here. They're taking the broad terms in the rule and defining it to include the threats to judicial safety. So we did that with 3.6, and then 8.2, we would say, statements, hold on.
Can we just do it in 8.4?
Yeah, I think it's I think it's a pretty big leap from the language of 8.2. Could you mind scrolling up?
Well, no, I just want to say that statements that have to do with the integrity of a judge or judicial officer includes statements that are threatening,
I don't
paraphrasing.
think that's the same thing.
Yeah, I don't remember.
You don't?
No, I think they're kind of two different things. You could make a threat to a person that's got great integrity, or you could
Oh,
slam
Well-
someone's integrity. They're not
And not threaten them.
right. That's not necessarily a safety issue, but it is a perhaps harms the administration of justice or the. But I
okay.
think they're kind of different things.
All right, you're right. Sorry.
Which begs the question, do we need, what is the value add of comment 1 to 8 point, now that we've spent an hour on it, what is the value add of comment 1 to 8.2 if it doesn't?
Because I don't know, because we're still trying to get at maybe you know, I mean, because this,
I mean, this
what we're
protects the-
saying is it's not, you know, we're not doing anything that would be vulnerable to challenge, because we're just stating what the exception to free speech is. And we don't want lawyers to be out there like, you know, with all the, you know, heated rhetoric out there.
Yeah.
You know, holding up opinion as their shield. And that heated rhetoric is what leads to these threats, even if their statements themselves are not threatening. So we're just,
Sure. So this protects the integrity of the judicial system, this comment. It doesn't get to the threat issue, but this would arguably,
it's in line with it.
if I made a statement that was false, that caused or that I asserted was an opinion, that caused on Twitter, that caused Joe Schmo on Twitter to then be like, oh,
Exactly.
this judge is drunk on the bench, so I'm gonna go harm them.
Exactly. Yeah.
Okay.
Yeah. I mean, I don't think we're saying anything controversial here that should be, and I think that it is in line with the goal here. Okay, should we move to 8.4?
So C and D of the rule itself are the sections that arguably this type of conduct would violate.
And A, because
Yeah, but A is you can't break the law, and so helping somebody break the law. I mean, that's
I mean, threats can also constitute a criminal act,
that's true, correct.
but like D is the catch-all, right? That's the
yeah,
rule that I hate.
Right.
Right on, like a really
I
high
thought you
bar.
hated 6106.
well, and then there's also respect for the judiciary. It was the what F, oh, it's 606.
It's a statutory,
That, yeah, it's,
which we can't add comments to, although it would be very helpful.
but we can reference them in our comments. So what do we have a comment? Did I do a comment? Sorry.
It's essentially the Yagman.
So why don't we just put what we put in 8.2 here?
We can, but it doesn't address the threats.
Oh, right. Okay. Can we combine what we said in 3.6 and 8.2 and put it here? So we don't have to reinvent the wheel. What did we?
Grab that? Can you grab this? We haven't fixed 3.6
No.
yet.
Oh, right.
Want me to have
Oh.
these? Or-
We're done.
Okay.
But we do talk about
Threats here.
Wait, if we were inclined to say the same thing in 8.4, which is a broader application than 3.6, should we just not say it in 3.6?
Wait, maybe.
do you want to just copy, just for now, copy and paste this language over to 8.4 so we can
Yeah, and then
Okay.
work on it there and
then go back?
Yeah.
And just put it at the bottom anywhere. And then grab the language from 8.2 when you're done. That's beautiful. Trying to unindent it. I'm hoping that it so you can see it all at the same time. You can just remove the file. So it's- Thank you.
Okay, so what's so prejudicial to the administration of justice and false misrepresentations are the two things that we're commenting on here.
So it's
So,
the, for purposes of this rule, extrajudicial statements that threaten that stuff, it's basically saying is prejudicial to the administration of justice.
Right.
Is what you're getting at. So I think you can delete the line 155 through the end of the sentence on 159, what ends in capacity.
Extrajudicial statements that threaten or attempt to threaten judicial officer safety, not ensures.
Instead of materially prejudiced, you would say,
Create a substantial likelihood. Wait, what is it? Prejudice.
it'd be
Prejudice
constitute. Yeah.
Sorry.
Go ahead.
Oh,
Vika.
sorry, I was just gonna say, or judicial recusal constitute conduct
Right.
that's prejudicial to the administration of justice.
Or statements or
So
conduct.
instead of where create is on line 157.
Thank you, Topeka.
It'd be constitute instead of create. So delete create. Conduct that is prejudicial to the administration of justice. And you can delete the rest of it. And then the italicized language is similar. It wouldn't be, we'd probably want to use one or the other or mesh them in some way.
Do we need for purposes of this rule?
No, I don't, not for this rule, because we don't talk about extrajudicial statements.
And do we need, does it have to, should it be extrajudicial statements or just statements?
I think it's just statements.
Yeah.
Which goes back to, do we need this at all in 3.6?
It's just,
Yeah, I think if we add it here, we don't need it there. See.
okay, statements that threaten or attempt to threaten judicial officers in a manner that
So
deters.
in a manner that deters or prevents judicial officers from performing their duties and thereby. Okay, so I think on 157, actual recusal. comment.
What'd you say?
After recusal on line 157, I believe.
Comma.
And then just leave it at that and take out the italics. And then that would be a comment. And then we can have the 8.2 comment as a standalone comment. Like that would be comment.
Do you, in that comment, do we want to add the reference to 61 or 6068? What is it? F, C?
The one that has to do with respect for the courts or respect for, or misrepresentation. Which one are you talking about?
I'm talking about, integrity of the courts and judicial officers. Let me pull it up so I'm not just making up whatever I think it says.
B.
Yeah, B, it's B. It's A, B.
And then should it be may constitute conduct that is prejudicial? So after the recusal, comma, may, M-A-Y.
I don't know if it deters or prevents a judicial officer from performing their duties. I can't think of a scenario where it doesn't. Right?
You know, I think my main problem was constitute is without an S and then statements is plural. That was just bothering me.
But I do, statements constitute, but there's so much in between.
Yeah,
It's hard
yeah,
to refer back to what it's actually, I agree. I was having trouble with that too. I was like, it constitutes.
Okay, so you want to put the business, see also business and professions code?
No, we had mentioned that as.
Maintain respect to the courts. Wait, so you don't want to reference it? I think we can. 6068E.
Yeah, I mean, talk about things that are, will it pass First Amendment? Maintaining
Well, it is weird because anything can fall under B
Right. Any of these things could also be a 601 or 6068B violation,
Yeah. But not,
but it's never
6068 is
charged.
constrained by free speech.
Well, all of it is, but yeah. And so that's maybe why it's never charged.
Right.
Okay,
Except
so
for
you know why
free.
they never charged 6068B violations.
Because they find it to just be like too broad of a,
First Amendment.
yeah, they just, they,
But that was Pavone was discussed 6068B, I think. Was it Pavone?
I thought Pavone was prosecuted under 8 point.
Well, one of them was I don't know, whatever, it doesn't matter. But I think
Yeah, they
either Mary,
never charged 6068 because it's just too broad.
No, Pavone was 6068B.
What?
Yeah, it says charging with 4 counts of failing to maintain respect due to court and judicial officers under BNP 6068B.
Or did the court find
Well, yeah, that's a good.
it? The court probably.
yeah, no, well, because yeah, they I can't remember because some of it wasn't. He was disciplined,
He was disciplined,
I
yeah.
don't know.
but then some charges were dropped, and I don't know if it was by the state bar. Yeah. But okay, so let's put C 6068B.
I think those are two, I mean, those are two separate. I mean, obviously these things aren't maintained. If you're threatening a judge, you're not maintaining respect to the judicial officer. I don't know if,
Yeah, he was found culpable under 6068B under counts 3 and 4.
Wait, so what are you trying to say, Erica? You don't think we should cite to it or not?
I think it's a separate comment, maybe. I'm not sure it's the same concept.
Oh,
Because are we saying that threatening is because of integrity of the judicial system?
Right. So what we're saying on line 155 is that this is conduct prejudicial to the administration of justice. We could say this conduct may also violate
Yeah.
6068B, but I don't think it's a C reference. I think it's this conduct may also violate.
okay, yeah.
I think there's a comment in 8.4 that does something very similar that we could just.
Or do you think that that reference goes in 8.2?
Or both. But it does, I think you're right, it does go more specifically into 8.2.
Like maybe next to the Yagman site about opinions.
And then C6068.
Yeah.
I mean, I can go all,
Sub B.
because I want the Yagman site to be here too.
We have it down below.
No, up there.
Wait,
Oh.
So what's on line 161 is what we decided to include in 8.2.
Yeah, so can we say, because I want it to be a separate comment because it actually goes to D or
I think it goes to C.
C and not D. Although it can go to D, I guess. God, I'm tired.
I know this is a brain day.
It's not usually like this.
Only when we work on rules. Is it paragraph C? So there's currently comment, if you scroll up, there's currently comment 5. Scroll up. So paragraph C does not apply. Which is, again, C is dishonesty, fraud, deceit. But should we add to that? Should it be added to that comment or right below it? So paragraph C does apply or may apply.
I don't know, because those are two totally different concepts. This is about like lawful covert activity and an investigation of violations of. I don't want it to get lost. And do we have to, if we're talking about a paragraph C in one comment, we have to cover paragraph C in that entire comment?
No, I just think that I think we should do it sequentially. So the comment that addresses paragraph A is comment 2. And then it goes to C and then
So you want to move the Yagman,
higher up.
yeah, that's fine. But it would be comment 6.
Or perhaps do you want does apply before does not apply? So
Oh,
we have
okay.
Comment 5.
Yes, yes.
And then current comment 5 would be comment 6. I mean, we got, there already is a comment 6, so we're messing with it as it is. I renumbering comments is not ideal.
Oh, really? Instead of just adding?
Because if a comment's ever, if it's cited anywhere and we
Oh, right,
refer
right,
it,
right, right.
it's gonna.
Oh, that's a good point. Boy, I don't even think about that kind of stuff, but yeah. I mean, I don't care. I mean, because can't you do like,
So you have current comment 6, which is, it does not apply to the First Amendment.
oh, well, then why don't we put the our
Right, so,
new Yagman here?
right, so maybe if you
Yeah.
could delete,
However,
Angela, after on line 149, that sentence of however,
all the way,
the whole thing.
except for the site. Well, yeah, because I want to keep C 8.2.
Okay.
Yeah.
Delete it.
Or C
Delete
also,
that.
or whatever, or this.
And then down below, you have the statement that asserted as opinion. Grab that. And we're gonna move that up to right after, it's right before the C rule 8.2. Keep that. So delete the bracketed, sorry, this is this one. Yeah, delete the bracketed one. And then delete the first citation, so the C and re-admin that.
But then put back this Penn site.
And yeah, and then so make that part of the same. I think it already is, but and then at the after 430, 1430, we do comma 441, 1441.
And do you think the however should be back in there?
Yeah. Yeah, I like that. But however, yeah.
And then do you also want would it be C rule? Well,
See,
so I think
also.
you need in Ray Yagman first because it's quoting from in Ray.
Right.
Where it,
Yeah.
so in Ray Yagman first,
Let's see all-
and then see also rule 8.2 and business and professions code 6068A sub.
I like that. Yeah,
See, writing together is really helpful.
it is.
So it's rule 8.2A. And then I know. Sorry. I mean, I made it real quick.
Sure.
You don't have to. Insert a section symbol here somehow. We will add an actual section symbol later when I can find it in there. B.
And then
And then-
statements, that should be 7. Yeah, I like this.
So the rule, the layout of the rule is paragraph blank does or does not apply.
Wait, what?
Should it, the statement, the way the comments work is, it says like paragraph A does not, paragraph C does not. Should we, for consistency in drafting, should it say paragraph D?
For here, for 7,
Yeah,
paragraph D.
may apply
Yeah.
to statements.
Yeah.
That's the attempt language still work with.
Where are we saying attempt to offend?
Since it has it prejudicial.
Do you think? Where do you think the attempt should go?
I guess I'm wondering how far you can go with an unsuccessful attempt that is actually prejudicial to the administration of justice.
Well, if an attempt to threaten judicial officer in a manner that deters. So if you're attempting,
This is the intent
is-
issue again.
I think threatening, I think it's not necessary. I think, how do you attempt to threaten? Right? So you did go to the wrong house.
Yeah.
I mean, yeah, I mean, that's true. Like, but
But I guess if we actually have to have a result of the threat, then we don't need to include the attempt, because if you attempt to threat, then there's likely no actual.
But an attempt to threat, is there, I have to be very careful in my enunciation. To have an attempt to threat, are you going to have to prove intent?
Well, you have to, under that, I mean, you would also have to prove intent under threat.
right.
I don't think, I mean, no, I don't think so.
Just
'Cause
look at the
statement
words.
Threatens or doesn't threaten.
Yeah. And look at who receives it as a right.
But
Not
there's
the-
also, I think you're thinking the criminal context, threats, the criminal statute.
It's still a specific intent crime.
Right, but
you
we're
can
not,
Charged with the attempted threats, no?
Yeah.
Yeah.
Right.
Which is different.
but we're not in criminal.
Yeah, that's what, yeah.
That's
so-
where I think.
So statements that threaten. So if you say something that you think is innocuous, but the judge finds it threatening, do you think the state bar court is gonna hold them accountable for that?
I don't think they would get them under paragraph D. They'd get them under something else.
I mean, I think the key part is the manner that deters or prevents a judicial officer from performing their duties, whether it's an actual threat or an attempted threat, that has to happen. And
Well, what
that,
about, it just applies to statements that deter or prevent a judicial officer from performing their duties.
yeah, I know, right?
Let's just take out all the threats.
Threats,
Yeah.
yeah.
Statements or actions.
Yeah, statements or actions.
But
Oh, wait, we need to have something about safety. Judicial officer.
right, because there are many, this is going back to what you said, I think, a bit ago. There are many statements that are made
Oh,
that
are disruptive.
necessitate postponement or judicial recusal that are not safety related.
Threatening statements that deter or prevent.
Statements.
So paragraph D may apply to,
I think threatening statements is good.
or do we just get rid of paragraph D?
Wait, what?
Not the comment, the clause,
Yeah,
not the
that's right,
actual
yeah.
paragraph.
So paragraph D may apply to threatening statements that deter or prevent a judicial officer.
No, because I want to keep in there threaten judicial officer safety or threaten the safety of judicial officers.
Can it just be threatening statements?
That compromise judicial officer safety.
That compromise judicial officer safety.
Undermine.
Well, then get rid of then threatening. So
Yeah.
threatening statements, that it should be statements that
That,
compromise judicial officer safety.
or could it just be affect judicial office?
Affect.
Do we have to go back and reference rule 3.5 about what judicial officer?
Oh, right, we forgot about that.
Just be human.
8.3, the rule in 8.2 did it.
Maybe we can,
No, we didn't do anything to 8.2 yet.
No, in the rule, 3.2
3.5?
sorry, 8.2 references 3.5. Like for purposes, it says
defining.
judge or judicial officer means for this rule.
Did we do that? We didn't do
No,
that.
no, it's in the rule, black letter.
Oh. Oh, God, my neck hurts from looking up at the thing.
I ended up bringing it on my screens.
Yeah, I'm like.
It's in current 8.2? I don't think so. 8.2 says almost nothing. That's why I'm.
Is it 3.5? It's 3.5.
Judicial officer means X.
It's 3.5.
Right.
Oh, I'm sorry, it's 8.4 F. So it says, for purposes of this rule, judge and judicial officer are the same meaning and role.
Oh, look at you.
Sorry, someone.
So would we just make, instead of tying that to F, would we just make it, what's after G?
Oh, so we're adding, wait, what?
So you want to take it out of F and make a new paragraph in 8.4 black letter?
Yeah, maybe, because it's not just tied to F at this point.
Or
Go for
we
it.
go to the terminology and suggest a change to 1.0 and then make judge, judicial officer a defined term.
But I don't think you want, I actually don't think you want that for many of the other rules.
But how often, candidate to the tribunal, how often do they use like judge? Yeah, I mean, I'm apathetic to that, but when it
That
says,
I think was very hotly discussed at RRC from what I remember.
what does it mean for purposes of this rule? Angela, would you mind scrolling up to paragraph F? A little higher. Right there, yeah. So what does it mean on line one, I guess it's 129? It says for purposes of this rule. Is that talking about 8.4 or 8.4F?
Oh,
I would hope it's 8.4, but I don't think it's,
So explain.
I don't think judge or judicial officer is referenced anywhere else in the rule until now in the comment. So maybe it's fine to leave it where it is.
yeah, it should actually say for purposes of this paragraph.
Right.
For purposes of the
Oh,
section.
not rule.
Right. So we can use that.
Yeah. 'Cause, the point was, should we move it to make it a paragraph G?
Right. Move
Or
what?
for
For purposes of this rule.
Or put it in a comment or something, because maybe you could just also remove it from the rule and put it in the comment for purposes of 8.4. You know, judge and judicial officer on the same.
I'm confused. You want to move for purposes of this rule there into G as a G.
I mean, that was a suggestion, like.
Yeah, so
There's
currently,
no other part of the rule that talks about, except for in the comment.
well, now there will be in the comment, but the comment is tied to paragraph D,
Right.
not F.
I know. So you think if we move it to a G, it's a standalone, and then it references judicial officers in
Which,
F and as well as the comment.
correct. I mean, I think you could eliminate the paragraph in what's now comment 7, the paragraph D prefatory language.
Why don't we just do that? I'm just
Because I mean, like,
That might be easier.
maybe we look at it like, like a judge is gonna look at this and say, okay, well, what's the plain language? It says rule probably applies to everything.
Right.
It's only listed in the rule once and then the comment, you know.
Right. The only point here being that if I was looking at the conduct that is prejudicial to the administrative justice section, I'm reading the comment that clarifies that threatening a judicial officer is that. I don't think I would go to F and be like, oh, that's what judge means in this rule. Like, I would not be focused on F at all. I would probably wouldn't even read it, even though
Oh,
I
I
could
see.
read the whole rule.
So you think that it's better to have it as a standalone because then it's clearer.
Or in a comment, right?
Or move the whole thing into a comment?
Yeah, for purposes of rule, because then the comment applies to the whole entire rule. Like,
Yeah,
I feel like changing the
I like that.
text of the rule though is a lot more work, right? Isn't it? No?
It's the same work.
Oh,
I'm
then
not the only person who thinks that, though. I mean, that's very.
Yeah.
That's been a
I feel like
question.
it's easier to add a comment.
Same procedural hurdles.
Yeah, but like I said in my comment to Wendy, it might be the same procedural hurdles, but is there more scrutiny applied to rules as opposed to comments because the rules are enforceable and the comments are just guidance? So like, yeah, I mean, we don't know, like there's no, but the timing of it is probably the same.
Right. There's no,
I like the idea of moving it just to a comment, like a standalone comment for purposes of this rule.
it'd be the lot, so it'd be new comment 8 then.
That's fine.
I think it's okay, it is both in comment and I'm just looking at other rules.
Yeah, and then, okay, and then we can keep paragraph D.
So you'd be eliminating it from 8.4F.
On comment
So-
7, did I hear someone suggest a while back expanding that to statements and actions
Yeah.
Or conduct.
or conduct?
Oh, this was
Yeah.
the civility. Remember, we spent a lot of time on this on civility.
What? Conduct versus statements? Vaguely.
It's a lifetime ago.
Well, and I don't think we're gonna get to how this fits into the civility rules. Or a comment to this, I didn't do a comment to the civility rules anyway. But I think the Michigan case is what provides some guidance on how the civility rules can be enforced on this with these types of statements.
I'm pulling up the petition to see what we ended up using there.
Well, can we put paragraph D may apply to statements that threaten or attempt to threaten a judge or judicial officer? The safety of a judge or judicial officer. So that it's consistent.
We used speech or conduct.
And what? So what are we doing here? So
So it would be
those
paragraph D
statements-
may apply to speech or conduct that threatens or attempts to threaten. Although arguably conduct would be criminal too, but. And then be that threatens or attempts to threaten.
the safety of judges or judicial officers.
What did you offer, Carrie? Because I think you were the one that offered that, which was, I thought, to take out this whole idea of threat and put it on what it.
I,
Oh, yeah,
I,
that's
I
right.
said may apply to threatening speech or conduct, but we weren't gonna be able to get the judicial officer safety in there, which I think is important to
Okay.
the stakeholders we're trying to.
You don't need judges because judicial officers is,
Well, oh,
oh,
that's what I'm just trying to mirror the 3.5.
but I think that's just because in, oh man, I think that's just because it says judge or judicial officer in 4, or sorry, in 8.4F.
Okay, just leave it. It's fine.
Oh, it does use judge or judicial officer.
Yeah, okay. That's fine.
Should it be prevents them from performing their duties?
Yeah.
And I would put judge or judicial officer. Be a judge or judicial officer. I think you can still use them.
Is it sufficient that it prevents them from performing their duties, or must it necessitate postponement or recusal?
Oh,
Yeah.
then take, just so we can take out and thereby necessitates.
No, I think she's saying the opposite. It'd be in a manner that necessitates postponement or judicial recusal, right?
Oh, I'm asking, but
I would
Yeah.
rather say deters or prevents them from performing their duties and take out and thereby necessitates. I don't know. I can't look at the screen.
What are their duties?
you could imagine circumstances where postponement or recusal didn't occur, but they should have.
Right. Yeah, I mean, anything that deters or prevents a judge from doing what they need to do is prejudicial to the administration of justice, right? Yeah.
So you
Delete what you have highlighted. And I think you can get rid of the commas now too, right?
Yeah, not true.
Yeah, so after officer and after duties, you can delete.
Well, I think you got.
After.
Yeah, I like this.
Should we, if we're good, should we copy and paste what's in 7 and go back to 3.6 and see if we need to do it
Do
there?
we need may constitute?
Or just constitutes?
Well, what about just
I think
duties
we might
period?
need something
Is it
before
paragraph
May.
implying that-
Wait, what did you say, Topeka?
Do we need something before May to make the whole sentence work? Something like insofar as it may constitute? Because we added the paragraph D language, which I think may make the final clause not work anymore. Does that make sense?
Say it again?
So would we want to modify
think-
slightly so it
I
reads
think you said it's
paragraph?
and.
Why do we need may constitute conduct if we're already referring to paragraph D?
That's what I'm asking.
Yes,
One or the
that's
other.
exactly what I'm trying to say. I
Okay, so
don't
could
think
you
we
just
need
say
both.
is prejudicial to the administration of justice?
Well, why do we even need that if we
I
say
think
paragraph D?
Duties, period.
Oh,
Or we get rid of paragraph D. Like,
Yeah,
I like defining what prejudicial to the administration of justice is specifically in this comment. So I would vote for getting rid of paragraph D. Because paragraph D,
so start with the word speech.
Speech.
Speech or conduct.
hmm,
Sorry, Angela, thank you.
no, it's,
although it doesn't really,
Yeah, perfect.
wait, may constitute conduct? Okay, because conduct is part of the role, okay.
And that's the first time we're using may now.
do you want it to say constitutes conduct? Or do you
I-
want to keep the may?
prefer may.
Defend. What we said?
So we're saying that speech is conduct here. Are we okay with that?
We're saying speech or conduct.
I know, but we're,
The second-
Constitute conduct? That-
Oh, I see what you're saying.
Right.
speech is conduct under D,
We can put.
and D is
may
limited to conduct.
be Prejudicial.
But I think that
Conduct
speech
is,
is conduct. No, can
oh, we spent a lot of time on this in this facility.
I know. Well, let's just leave it and see what happens. I mean, I mean that in a way that we can revisit that.
Yeah, no, this is going to CJA. This is going to the working
Yeah.
group that includes CJA.
And we
So
can-
I don't,
Novella, what are you suggesting?
Can we put it like just a note,
May,
speech versus conduct or something
instead
like
of
that?
constitute conduct that is, may be prejudicial to the administration of justice.
The rules
Make
are
a-
complicated unless.
That
it's
may
conduct,
be, right, because if the speech, are you,
Oh, okay.
it has to be,
That portion of it.
well, and there's the question, is speech conduct that's prejudicial to the, I think you actually need this to, because this is now saying speech is conduct,
right,
Yeah.
which you need for it to violate
D,
D.
right?
Because the rule is.
Conduct.
it's
Conduct.
Professional misconduct for a lawyer to engage in conduct that's prejudicial to the administration of justice.
But
That's
I
a
think it means, like,
question.
it's not like you're just out there silently doing stuff.
Right, has to be speech, right?
What?
Subversive, by the way I looked at her.
First Amendment, so we don't, it doesn't have to be.
Yeah, I know, but it's interesting that the rule is limited to conduct
know.
and it presupposes it's what you're saying, like, that's all lawyers do is say stuff.
Right.
So it's not like we're out there, you know,
Yeah.
like, so I think,
Giving the evil eye.
yeah.
Well, doesn't speech, like the First Amendment protects speech, not conduct?
No, association, all that stuff, right?
Right, but they're enumerated, like, that's not grouped together as conduct.
What? The First Amendment, the First Amendment protects conduct if it's communicative, right?
Yeah,
Which
but
makes it
there's-
speech.
Which is speech.
That's the
Oh
thing.
my
So
God.
that's the thing. So conduct that, like armbands, right?
Right.
That's conduct.
Expressive conduct.
Right. Expressive conduct is construed as
Burning the
speech
flag,
by case law. That's construed as speech.
right?
Right.
But
Making
what
a
are we saying
statement.
here? Speech is the communicative conduct.
We're saying
We're saying the opposite. We're saying D includes just not just communicative conduct, but also speech, like literal speech.
right, which arguably has a higher First Amendment threshold.
I don't think,
Protection.
but I don't think that's, oh, it could. What's an example of conduct that's prejudicial to the administrative justice that doesn't include speech that a lawyer can engage in?
And all lawyers do is speak.
Right. I mean, that's the thing. Like go in there and just like,
Vexatious litigation is.
but that's also speech. Filing something
Yeah.
over and over.
Going into a courtroom and taking a picture of the judge.
Yeah,
Mhm.
that's okay. That's a good example. I can't think that that's communicative. That's actually
That's not
like an
speaking.
Right, and
action.
if you're doing it to menace, like to threaten them,
Threat.
it's like I'm taking a photo of you to,
Yeah.
give it to my cronies or whatever.
Yeah, but that's a very like, okay, so we can name, like, that's one example. That's very, there's a lot of other
Going
stuff.
in and flashing a weapon at them.
That's communicative.
Well, I think
But it's
actually-
conduct though.
can you
Citing illegal activity.
flag this and just say it does adding speech
Change the rule,
change the rule?
like to go beyond what the rule prohibits.
Yeah.
Yeah. Man. I think that's a really interesting. I just think that like 95% of the conduct that they're talking about here is speech,
But what about like driving, if you're like driving in front of, if you go.
Crash into the courthouse.
No, like if you drive in front of their house every night, multiple times, like you drive slowly in front of their house, like that would be threatening
Threatening.
probably, depending on your intent.
But
Aren't there First Amendment,
Exception for reasonable restrictions.
like time,
But I
place,
think it
manner?
would be content neutral, which is interesting, because we're talking about threats. Like if it was
Well-
anything that disturbs the administration of justice, it might fit under the content neutral.
So I think,
Law.
well,
Kind of strange, but.
is there case law yet that says the
Right.
act of posting speech on a social media platform? Because that's mostly what we're talking about here, right?
Right.
The is posting speech on a social media platform, is that conduct?
No, that's speech.
That's speech.
Yeah, I would say that's speech.
Okay.
The thrust of it is communicating. So I think that's probably what we're getting at. But I just think that the word that the word conduct in this rule shouldn't be conduct. It should be, because I just don't think that the drafters were just intending to capture just physical acts versus speech. I think they were intending to encompass what lawyers do. Or maybe not. Am I wrong?
Like, there are some really unhinged lawyers that will do things that are not speech that would still be threatening.
I don't disagree with that, but I'm just saying, like, the rule doesn't, I don't think the rule was intended to exclude all the other stuff, which is speech.
Well, we still have 6 that says punted and says activities.
Wait, what?
If you scroll up, This rule does not prohibit activities, which could be conduct or could be speech.
Oh, this is original.
Yes.
This rule.
They couldn't figure this out either, maybe, and that's why it says activities.
Okay, then
Oh
let's
my
just change it to
God.
activities that threaten or to.
Speech or activities that threaten.
Broader, yeah.
But again, the rule is conduct prejudicial.
Right. And it doesn't matter what,
Yeah.
I mean, we could say anything, we're still making the inference that an activity is conduct,
Conduct.
which an activity could be speech or it could be something else. So I don't think it helps with the First Amendment.
Well, what if we, I mean, to really, to survive scrutiny, why don't we take out speech altogether, conduct that threatens, I mean, threatening conduct, well, no, I take that back, because then it's the, going in and taking the, which is not, what we want to get more than that. I think we just need to figure that out. I don't know. I mean, I guess the question is D intended to capture speech that's not protected by the First Amendment? Wait. Yeah, so now we're back to because this rule does not prohibit those activities in particular that are protected by the First Amendment. Okay, so we have the opinion, but prejudicial to it still can be prejudicial to the administration of justice if it's protected speech, right?
Yes.
Right?
Yes,
Yeah,
yes,
I think so.
yes.
That's what Rule 6 says. So we can't say 7 because we're saying speech. So we would have to say, unprotected speech or conduct. Do you know what I mean?
Could you just put what's currently in 7 as part of the beginning of 6? I mean, I think the problem then is what you have is however, but I mean, there's a reason this was the last comment to the rule originally.
I think we take out. Let's see, so what we're trying to say is, the exception to the First Amendment that we're talking, the Yagman rule applies to threatening speech. That's what we want to kind of say in 7. Otherwise, threatening speech is going to be protected unless it's incitement. So I think 7 is vulnerable under the comment in 6, the first part of 6. So I don't know what to do about that. I think we need to either get rid of speech altogether in 7 and just say conduct,
Activities.
or or activities. But then we're actually.
Well, I think if you do activities, there's an inference that it's conduct, and then there's it's charged, and then there's the First Amendment.
And then there's a
Defense.
question whether or not,
Yeah,
and then there's a question of whether,
question.
and then that's,
And that's what
that's what,
Pavone was, Marla Brown was, all of those cases where they assert the First Amendment defense.
okay, yeah,
You
so it's
do a
just,
string side to cases where First Amendment defense works, cases where it doesn't.
that's not a bad idea.
Well, Pavone's not published, and then
We have, we don't have that many.
I don't know if Marla Brown.
Marla Brown I think that would be misleading because Marla Brown, she got off and it really wasn't about judicial safety or anything. It was about,
So it would be activities that threaten, and then
yeah,
they figure it out in state bar court.
yeah. And I think we're still achieving, exactly. Because that was my yeah, I think we're still achieving our goal because we're talking about threats to safety. We're talking about what's not protected. And we're not going any further
Attempt
to go beyond what the Constitution prohibits. Okay, I think this is good for now. What do you guys think?
I agree. I agree.
So we just have a bunch of text associated with 3.6 still.
And
Do you need-
I think we just
No,
get rid
I-
of 3.6.
Yeah, we could
altogether.
just eliminate it, but I think we need to, I think the group should decide that if that's.
Yeah, let's get rid of all of 3.6 and we can put it back. Like, again, we can talk to CJA and see what they think.
So go, scroll down, you.
And,
Get rid of the comments.
It's from 3, yeah, it's all that stuff.
Oh,
There might be federal cases. I don't know if we want to go there. Talking about like.
We
what-
will leave it to the discretion of the working committee.
Oh, I'm sure there
Yeah.
are.
I'm sure there are.
And then that comment 3, you can get rid of.
even though ironically 3.6 is precisely the rule that that really
You're
fits into
concerned.
what we're talking about, I think.
well, I think we were acting like we can't change the text of the rules. So you could-
Yeah, I know. We'll just,
Because I had the same assumption as Amelia. I mean, I thought it was harder to change the.
No, I think everyone has that assumption. It's
Yeah.
the exact same. I mean, maybe I could
Because
not
it's
tell you
more
what the Supreme
important than the
Court
comment,
thinks,
right? So
right?
it seems like it's a bigger deal.
But procedurally, it's the exact
same
same
deal.
process.
But again, this is trial publicity, which, you know,
You would just have to change a lawyer who is participating or has participated.
I don't think, I mean, I would just suggest that 8.4 catches what we need to catch. I don't think a lawyer who's in a case versus a lawyer who's out of a case, either one is more at liberty to threaten a judge. I think 8.4 should get the gist across.
yeah,
I would hope.
well, and I think that's what we did. Yeah, and because this is 3.6 is more focused on particular conduct that covers it. Yeah. Okay, so we have to, the only thing that we didn't get to is the civility doing a comment to the civility rules. But
Right. I think though, if I mean, I think it's a stronger charge.
if well, like, okay, so in the Michigan case, the judge, the lawyer, Michigan has similar civility rules, and the lawyer went out, and it was an appellate judge after the ruling. So I'm just
Is
thinking.
this the radio host?
Yeah, he goes on and he calls the judges, liken them to Hitler and something else. They called them like idiots, basically.
But I don't think under 8.4.2 as proposed, we limited incivility to conduct that is abusive or harassing.
Oh, right. But so in Michigan, it was
It's
discourteous.
much broader, and that's the wunsch. So like wunsch,
Right.
there's other states that have a version of 6068, whatever it used to be,
Yeah.
where it hasn't been struck down.
And that's Michigan. You're right. So Michigan's was more in line
It's
with
broad.
that. Okay, so let's not worry about that. I mean, I think harassing fits, but it's also, it's something we can still address it. But I think we've captured what we need to capture with just the 8.4 and 8.2. Okay, now what?
So I think there, since everyone's brains may be like mine at this point, the only things left on the agenda were quick items.
So
I think we're on to ethics quarterly 4.11.
So let's do, okay, for that, this is what I'm presenting, I guess.
I could give a quick update on the abortion access issue if you'd like for a minute. Okay. So as it relates, just a quick status update on the abortion access opinion. So for those of you new to the committee, when Rule 8.3 was being developed, Rule 8.3C the paragraph says that there's no duty to report lawyer misconduct if the misconduct would not be construed as misconduct in California. So it basically protects lawyers who are engaged in what would be misconduct in another state, but is not in California. And that was raised specifically by the Overarching Reproductive Law Project, which is a group, and they raised this in two ways. They raised it as it related to 8.3, but then they more broadly raised this issue as to how to address concerns that lawyers may have in assisting someone in getting access to abortion-related care, or frankly just reproductive-related care, depending upon the state that they're dealing with. And this has come up because there's, many companies have employees in different jurisdictions, and many companies have indicated they will help pay for people to travel out of those states. Uber, I think, is one of them. And so is that, by having that policy that was probably went through their in-house team, is that person assisting in misconduct in that state? So there's two things here. And then statutorily, if you are convicted of a crime or you are subject to discipline in another jurisdiction, you're required to report that to the state bar. And proof that that is not a crime in California is an affirmative defense. So you still have to go through the process to some extent of the discipline, assuming that OCTC were to prosecute this. You have to go through the affirmative defense process and raise that. And so you still have that like public tarnish to your license. And so this group over a year ago asked for the committee to address this. The committee has spent some time in this issue trying to figure out if this is something the committee can frankly opine on in the way that that this group has asked to. We've had discussions about how there's a constitutional right to reproductive access in California, and if that would supersede and preempt the rules of professional conduct and these statutes that make it reciprocal discipline. It's not totally clear. So that's the backstory. Long story short, the update is that we had discussed at COPRAC indicating that this should be a legislative priority for the state bar to address at our September meeting. I've been in touch with one of the members of that group, and they have found an assembly member who is going to carry forward a bill and present the bill so that the state bar could support it. So there's no language yet. They will likely have language sometime November, December. And then as we've discussed, typically the state bar develops its legislative priorities, which are then approved by the board at its early 2025 or early year meeting. So everything seems to be on track. That's basically the update.
One quick point about that. So 8.4 comment 2 says that paragraph A does not prohibit a lawyer from advising a client concerning action the client is legally entitled to take. So wouldn't that cover most of a lot of like what we're talking about? Like the Uber example that you gave, the lawyer in-house is counseling Uber on, a policy that allows their.
Sure.
Yeah.
But if that lawyer is also licensed in Texas
Like,
and Texas disciplines them as a lawyer, then by statute under 60680,
You're talking about the,
they're required to report it to California, or if they're criminally convicted in Texas for doing that assistance, they're required to, OCTC would be made aware of it either by the lawyer or the fingerprinting. And so then that's the affirmative defense is tied to reciprocal discipline and criminal convictions. It wouldn't be charged as a violation in California. It's really just for those who are either criminally convicted in their role outside of being a lawyer or have multi-jurisdictional licensure.
That's like an 8.5 analysis for the choice.
Correct. Yeah. Okay. What are we doing? I can talk about what we have. So on left on the agenda is very high level items. So talking about ethics quarterly, and if we want to talk about possible topics and assignments, just high level ethics symposium, which I can just address. It's just that at our next meeting, we will start talking about it more seriously. So if you have ideas, the ethics symposium is usually in May. So we're about 6 months out, which seems like a long time, but it won't be. So to the extent there's interest in serving as a panel moderator. For those of you who have maybe not attended the ethics symposium, it's typically a co-prac member moderates a panel and participates, and we bring in other people to speak, with the exception of one panel, which is the basically typically it's been co-prac officers who talk about new opinions and new cases that are relevant to professional responsibility. But as far as the topics, there's typically always, like last year was AI. Year before that, there might have also been AI.
Implicit
I'm
bias.
sure there might be AI.
This year there might be AI. And there's typically one that qualifies for implicit bias or elimination of bias credit. And then there's typically ones that talk about like specific professional responsibility issues. So I think last year it was like a small solo lawyer
That's
focused
excellent.
presentation.
Yeah,
Joel?
yeah.
Yeah, so there's different opportunities there. So this is just to put it on everyone's radar, to start thinking if you have topics you're considering, feel free to send them along to us.
Free speech.
Yeah, right.
Yeah,
I mean,
and maybe,
yeah.
yeah, and
This whole thing, right?
yeah. And it could be tied to civility. It could
Yeah.
be tied to
All of it.
statements about judges.
Yeah.
It could be all of
We'll
those
just
things.
get under the umbrella of free speech.
Yeah, and civility is a new MCLE requirement, so that'd be an excellent one. So that's that item. And then the only two other items are to solicit new working group members and consider new opinion requests. We did receive one since our last meeting, but I was going to include that as part of an inventory that we had talked about doing for the December meeting. So we'll talk about where we are on opinions, what still exists in the inventory, whether things should be moved forward or if they should be tabled. So, conversion clauses, cryptocurrency are two that are a little bit, one installed because there's just been no action on it. One installed because it's hard to agree on what to do.
I think the new working group will have it well.
Done. It'll be done by
It's done now.
December. And then if there's any other topics that people think are worthy of an ethics opinion, the group it'll be kind of part of a little bit of a mini planning session for the committee for 2025.
What about, did you talk about the client file release opinion?
No, so that's the last thing to talk about, is to just kind of very quickly go through the opinions that we didn't substantively talk about today. I'm happy to do that if you'd like, Cassidy, or you can.
Well, let's talk about, I can, I mean, you've talked a lot,
Go for it.
I'm happy to do it, but let's, so just quickly on the ethics quarterly, I mean, we can, I don't have any, I think we can just target to talk about it at the next meeting, because I'm thinking the judges thing will be the first one, and we can plan to maybe roll it out the first quarter of next year. So let's just,
We had talked about doing one about FinCEN and the business, what's the new
CTA,
BOI?
Corporate Transparency
yeah,
Act.
Corporate Transparency Act? Yes, thank you.
oh,
For only
Actually,
limit
I
in
think
limit.
a couple of days ago, there was an opinion that was opposite, but.
Oh, no.
So.
well, we could,
Unclear, there's an opinion.
And the injunction's narrow.
Yeah.
So
what will it take administratively to issue quarterly? Because if it's something that can be done
yes.
before the end of the year, then maybe we should do that one.
Are we announcing like a program for quarterly? Are we committing ourselves to
Yeah.
quarterly, or are we just doing like
Random.
periodic?
I think, well, what do
So
we?
they've been called various things. It's never been quarterly.
Okay,
Called quarterly, I don't think.
so we're just using that.
It doesn't have to be, we could call it, it used to be.
Discretionary.
Yeah, two things used to happen. There was a hotliner article that was either written by staff actually on the ethics hotline or co-prac members at certain times. And then there were also MCLE self-study articles that used to be written by co-prac. And so that's certainly something that could be done, is one of these things could, an article about judicial threats, or article about Corporate Transparency Act, article about 8.3, article about
Like a good service.
whatever could be offered for self-study.
I think that Yeah, I mean, I think the quarterlies are probably easier than the self-study.
Sure.
Because they're long, the self-study ones, I recall, they're longer and they have all the questions,
Quiz.
blah, 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 yeah. Whereas a quarterly can be like 500 to 800 words or something, pretty straightforward and not too difficult to assign and do.
Any idea what the audience, I mean, the self-study, there's some value because people are getting MCLE, right?
Yeah.
But do we know what people?
No, I mean, I think that there's for what it's worth, the ethics hotline used to refer people to them when they called if it was on a discrete issue. So I think there's value.
Self-study?
The hotline articles, so just the articles.
Oh, okay.
And then additionally, the State Bar's Communications Office is trying to be when they send out communications, they're trying to include, resources for lawyers. They're trying to promote kind of more of that. And so this is something that they could include in that would go as part of an all licensee distribution, and then lawyers would see it and then decide if they want to read it or not. And then we would have, if it's in that, we would actually get clicks. So I could tell you.
Reading them.
Exactly.
Great.
So do we want to assign one for the FinCEN?
Dan is not here, and I believe he volunteered to
Oh, he did?
do it in the past. So I can reach out to him
Okay.
and see, unless there's someone else who really wants to.
Only me.
What were we thinking with CTA? Was there
The thought was to clarify 1.16 termination and clarify when representation ends and communication. So I think it was I believe the thought was that it was a 1.4, 1.16 article explaining that the no need for ongoing duty so long as it's clear to the business that they have the obligation to update this in the future. I believe that was the thought there. There's a ton of FAQs on this, but none of them touch this.
CNA actually has a good in practice about the Corporate Transparency Act and like this issue, whether or not you have this
Ongoing.
because you're talking about the ongoing duty to update.
Correct.
FinCEN stuff. Yeah. So CNA has one.
So maybe, looking at that and drafting something, just for what it's worth, we in our office have gotten a lot of calls from non-lawyers because apparently something's gone out to many CPAs through their carrier that says, watch out for UPL in this area.
That reminds me,
Yeah, we're in a good segue.
we were gonna see if we were ever allowed to opine or talk about
Oh,
what is the practice of law?
It's
Where
still,
does that go?
so we're still in the process of sub-entity
I
review.
keep hearing about this. It's very exciting.
The board will be hearing about it at their November meeting. My understanding is no action will be taken. But as part of sub-entity review, they are looking at whether or not the UPL restriction should remain for this committee. And then again, as of, I think it was 1994, but don't hold me to the year. In the 1990s, the board issued a resolution that COPRAC cannot advise on the unauthorized practice of law. And so that has remained in effect and
Is it advise or opine? Like, does it mean that we cannot?
touch it.
Yeah, so it makes some of our opinions really weird.
Like the ethics
we
of working
stop and
remotely.
go around the issue.
So that's going to be, when we were looking at AI,
Right.
that's an area where it's definitely relevant. Looking at the opinion that exists, that the ethics of working remotely, that exists there as well. And there's many other areas where it's relevant. So
yeah, it's kind of well, is it because it's like it's a criminal, it's seen as an attorney general type of, it's under their
it's an
purview?
antitrust issue.
But
Oh,
now we're under the Supreme Court, right? There's CLA is a different organization, and right, doesn't that fix the North Carolina dental?
There's an open, so in theory, yes, but the question is, would the board approves these opinions? Like, would the Supreme Court have to approve these particular opinions that address UPL for the dental board case to?
Yeah, but I thought because the Board of Trustees now has public members and because it used to be that.
It's still not a majority, I don't believe.
they could agree on
Yeah, so I think, yeah,
Okay, so that's ethics quarterly. Do we want to go through the the opinions that need working groups? So,
Should we just wait until next time with what Erica said about bringing all of them to the table?
oh,
so the only ones that,
Maybe.
the only one I would briefly like to talk about is just, the arbitration advisory.
Okay.
2022-OXB, because Elizabeth is a one-woman, working group on it, and she's leaving. There's not much to do on that one. It's just to basically review it one more time and add some, incorporate public comments a bit more. So if the committee wants, staff could do that before the December meeting, and then it could be brought back.
Is this the one that talks about expenses and all that?
Reasonableness of fees, yes,
Yeah,
yes.
I'm happy to help, but.
And it's to add Shepherd Mullen in, essentially, yeah, and a lot of the work has been done. So yes, if someone wants to,
Happy to take a look at it, but.
great. Great. Yes, yeah. Anyone else wants to too, I would love it.
I mean, and why is it called an arbitration advisory still? Like, why, like,
So COPRAC does the arbitration advisories, now that the MFA committee's gone.
Mm.
So for the mandatory fee arbitration, that's the resource for their arbitrators to follow. But it has application and use outside of that.
yeah, I mean,
Yeah.
like. I've
and now we're
But does
talking, yeah.
does it go through all the same public comment stuff? I
It
can't
goes through
remember.
all of the rigmaroles of a COPRAC opinion.
Oh, well, I like keeping it separate though, because it's,
The numbering separate is actually very helpful, I think, for,
but yeah, and it's also just a good place to go to about fee disputes.
Mhm.
Yes, without having to wade through all of the ethics opinions, although those apply too sometimes. But, okay. Okay, anything else? Are we at the end of our agenda? Sort of.
So Erica, you will take the lead, Emil will help you, you'll be coming back with what in December?
hopefully, I said this morning, so I'm going to jinx myself. Hopefully an opinion that is ready for the committee to review and adopt. It's an
And
approved
adopt.
opinion. So we have an opinion. This is arbitration advisory 1998-03. It's just updating it to incorporate new laws that have been developed in the past 26 years.
It's
Right.
not substantive, basically. It's just kind
Well,
of like.
it gets a little bit substantive.
Yeah.
Because like
So
the
then-
Pesh decision.
Does it have to be put out for comment?
It already went out for public comment.
Oh, right.
So it's just incorporating any additional public
Comment.
comment that the group wants to incorporate.
Perfect.
I don't think there's any substantive changes,
that it has-
but I said that this morning.
Right.
We'll see.
And so it should be relatively straightforward.
All right, but we'll decide, okay.
Yes.
Okay.
Great job, Chair.
Oh, thanks. Thank you to Erica for the heavy assist.
COPRAC accomplishes the peaceful transfer of power.
Exactly. Without any disputes,
Yep.
attempted threats.
All right, well, thank you, everybody. Meeting adjourned.
Bye, Topeka. Thank you.
Thanks,
Bye.
everyone. Bye.
Question. When we're setting the meetings, will